Well, good afternoon all, and thank you so much for joining me. We haven't had a dramatic makeover in the conference rooms at 5 Essex Court, nor is this some weird move to the country style broadcast. But as you can see, I am working from home. Now, whilst deepest Shropshire has charms that are obviously too numerous to mention, we are not yet blessed with the best broadband in the land. The connection was fine when we tested this yesterday, but I hope that the technology both here in Shropshire and you wherever you may be works well enough for all to take part. Tiny bit of housekeeping before we start. For those not familiar with Zoom, there's a chat function in the bar at the bottom of your screen. Please use that either to ask any question or to let us know if you have a problem with the feed. If you do have a question, please can you preface what you ask by typing question in capital letters so that we can more easily filter out what's coming in. We're going to try and scoop up all of those questions from the chat and answer them at the end of this webinar, albeit those answers, of course, likely to be a little bit provisional because we're still waiting for the dust to settle on the bill. We're also planning on disseminating, hang on, I've just got a message in. Looking forward. Okay, we started already. Okay, I can see there's 141 people there. I'm hoping, have you found the chat screen? If any one of you could kindly type a message to say that you've heard it's watching from home and it's working. Yes, excellent. Thank you very much indeed. So I don't need to start again. Brilliant, thank you. So we are planning on disseminating a summary of the Act once it's been given royal assent, and we will try also to include any outstanding issues in that note when it comes out. So welcome again. This is the first presentation in the SOFA series. It's a number of informal talks given remotely by friends and colleagues of mine at 5 Essex Court. We hope this series provides an informative, but also frankly, a welcome disruption to your cabin fever, as we all get used to the new normal of isolation following the Prime Minister's announcement on Monday evening. Next week, next Wednesday, Claire Palmer is going to be giving a talk on the employment law issues that arise from COVID-19. But no doubt you will be relieved to hear that the series is not exclusively about this wretched virus. We already have plans to give case updates on information law and data protection law, as well as something on the new 2020 police misconduct regime, and there are various other topics in the planning stage. We're going to be publishing a schedule of what those talks will cover, and of course, if you have any suggestions for topics you'd like us to deal with, then do please submit them either via the chat icon at the bottom of your screen or simply email George Connor and she will pass it all on to us. Now, for those who haven't yet met or spoken to her, George Connor is our new head of marketing and she's very largely responsible for putting the mechanics of this series together, along with our very own Aaron Moss. George is your point of contact for anything to do with this series. Peter, I know you have separately emailed a number of questions particularly about employment issues. I'm not going to address those today. Those are going to be picked up either by email later or indeed covered by Claire next week. Finally, thank you again for joining me. Do please spread the word amongst your contacts and encourage them to sign up for the series too. So, the coronavirus bill and the powers of the state. There are two new major legislative instruments. Firstly, the Health Protection Coronavirus Regulations 2020, which came into force on the 10th of February. And secondly, the Coronavirus Bill, which is currently going through Parliament. It went through the House of Commons on Monday evening, and it's at the Lords Committee stage today. It's expected to receive royal assent very soon, possibly as early as Friday of this week. So the Act, as it will become, is the future. But where are we today? Under the Health Protection Coronavirus Regulations of 2020, well, they came into force 10th of February. They provide a number of new powers for the Health Secretary and registered public health consultants. And the regulations work in this way. Regulation 3 requires the Health Secretary to declare a serious and imminent threat to public health before the measures in the regulations may reasonably be considered as an effective means of preventing the further significant transmission of coronavirus. That declaration, which is fundamental to all that follows, was made on the 3rd of March of this year. That declaration, which is fundamental, can be revoked at any time. Well, now that the declaration has been made, the powers in the regulations can be exercised. These include, broadly speaking, a power of detention, a power to compel someone to go for screening to see whether they are infected, powers to impose restriction on travel, on activities, on contact, and a power to keep someone in isolation. In a little bit more detail, Regulation 4 enables the Secretary of State or a registered public health consultant to detain someone for 48 hours or such longer times as needed for any screening requirements to be complied with, and 48 hours for the purposes of screening, assessment, and the imposition of any restrictions or requirements. There are 2 preconditions that must be met. Condition A: the Secretary of State or a registered public health consultant has reasonable grounds to believe that P is or may be infected or contaminated with coronavirus, and they consider there is a risk that P might infect or contaminate others. On any view, a fairly low bar, condition A. Condition B is that P has arrived in England from anywhere, including Northern Ireland, Scotland, and Wales. And the Secretary of State or a public health consultant has reasonable grounds to believe that they have left an infected area within the 14-day period immediately prior to their arrival in England. The infected area is on a list that is published on the government website. So those 2 preconditions. Regulation 6 goes into a degree of detail about screening requirements, such that you can compel P to answer questions about their health, their history, to produce documents, and to allow a biological sample to be taken or for themselves to provide one, and for them to provide their contact details. Under Regulation 7, once P has been assessed or has been released from detention or has been released from isolation, they can still be made subject to restrictions on travel, activities, and contact with specified persons for up to 14 days. Regulation 8 is perhaps one of the more strident, because this is the regulation that enables the Secretary of State or a public health consultant to require a citizen to be kept in isolation. The test there under Regulation 8 is whether the Secretary of State or a registered public health consultant has reasonable grounds to believe that P is or may be infected or contaminated with coronavirus and considers it's necessary and proportionate to do so in order to reduce or remove the risk of them infecting or contaminating others. As we probably all know already, there's something of a cost to isolation and to the current new normal. You yourselves will have suffered too much confinement. Reassuringly, perhaps, there is also now an obligation to have due regard to the person's well-being if they are being detained or kept in isolation, and to review any continuation of their detention. Finally, for these purposes, a person who is subject to any restriction can appeal to the Magistrates' Court against any such restriction imposed. Presumably, that will now take place via video link. What, though, of the police powers under the 2020 regulations? Well, those are really found in regulations 13 to 15. Firstly, regulation 13. In respect of any of these requirements, where a requirement is imposed on a person to be detained or kept in isolation, a constable may do any of the following. A, take the person to a suitable place for the person's detention or isolation. B, may keep the person in detention or isolation. So this is where somebody else has decided that they should be assessed. A constable may take them there or keep them in detention or isolation. What if a citizen doesn't like that very much? Well, where a person absconds from detention or from the isolation imposed, a constable may take that person into custody and return them to the place of detention or isolation, or take them somewhere else, another suitable place. And covering all of this, a constable may use reasonable force if necessary in the exercise of such a power. So far, it's just enforcement. If we leave aside Matt Hancock or a registered public health official What can an officer do when they're on patrol? Well, we find that in Regulation 14. This regulation applies if a constable has reasonable grounds to suspect that a person is or may be infected or contaminated with coronavirus. There is a risk that he might infect or contaminate others, and it's necessary to direct, remove, or detain him in the interests of P, for the protection of others, or for the maintenance of public safety. So these are powers specific to an officer on patrol. Well, what can they do? If all of those triggers are pulled, what can they do? Well, a constable under Regulation 14.2 may direct that person to go immediately to a hospital or other suitable place for the purposes of screening, assessment, and the imposition of any restriction or requirements. Pause there. Try and think that one through and how that might work. An officer might direct a member of the public to go to hospital. There's nothing immediately obvious as to why that citizen would cooperate. And that's where B comes in. A constable may remove P to a hospital or other suitable place for the purposes of the imposition of any restrictions or requirements. In other words, the policeman can simply put him in the police car and drive him there. And finally, under this power, if P is already at a hospital or other suitable place, the constable may keep him at that place or remove him to another suitable place. Now that power can be exercised, that power to direct someone to go, to remove them physically, or indeed to transfer elsewhere, may be exercised where P is at any place. This provision is wide-ranging geographically. It's not limited to dwellings, not limited to public places to which the public have access, not in any way embargoed against going into a private premises. And for the purpose of exercising the power in any of these provisions, a constable may enter any place. Just a word of caution, obviously. The wording of that is, for the purpose of exercising the power, a constable may enter any place. That does not, of course, give a constable carte blanche under the guise of these regulations to enter without criticism or legal vulnerability. Now, before exercising any power to direct, to remove, or to transfer, the constable must, albeit this is in brackets, notionally, must, so far as reasonably practical, consult a registered public health consultant, must have due regard to any guidance issued by Public Health England. Pausing there, no doubt for those professional colleagues amongst you and those in the force, in various police forces, you may well have this already on your intranet. If you don't, I recommend you put it there. And if the officer cannot, for whatever reason, take that consultation from a registered public health consultant, then he must do so as soon as reasonably practicable after he has directed, removed, or transferred P. And again, for this provision, a constable may use reasonable force if necessary in the exercise of a power under this regulation. So if you have an officer on patrol who deals with a member of the public and the officer reasonably believes he has symptoms, etc., such that he's going to remove him to a hospital and the member of the public does not wish to come, the officer is entitled under this regulation specifically to use reasonable force if necessary to do so. How long does this all last for? What is the period of detention? Well, initially it's 24 hours. Now, under the regulations, this is where we are today. The 2020 regulations, remember, this is a decision made by a constable. It is the constable who has reasonable ground. The constable can detain for 24 hours, and bizarrely, I think, a constable may at any time before the expiry of that 24-hour period authorize the detention of the person for a further period not exceeding 24 hours. So the same officer can give himself or herself another day in which to satisfy this power. However, that extension can only be given if the person giving the authorization, i.e. could be the same officer, considers that the extension is necessary because it is not reasonably practicable for the imposition of any restriction or requirements under Regulation 5 to be completed before the end of the initial period. In other words, If the officer takes a member of the public to the hospital and the hospital say we're completely rammed, we can't deal with this today, that individual can stay there somewhere, somehow, not entirely clear, and be dealt with in the following 24-hour period, simply because there isn't enough capacity. What are the consequences for failing to comply? What happens to the member of the public who isn't interested? Well, there's a criminal offence. There's a whole raft of them. Under Regulation 15, the person commits an offence if they fail without reasonable excuse to comply with a restriction or a requirement. If they're told to stay indoors, not to see their neighbours, not to go shopping, not to do whatever it is, and they fail, they're in breach, they commit an offence. If they abscond or attempt to abscond from their place of detention or isolation, if they provide false or misleading information intentionally or recklessly to any person carrying out a function, they commit an offence. If they obstruct without reasonable excuse any person carrying out a function under these regulations, they commit an offence. Likewise, what about children defined as those below the age of 18? Then there's a responsible adult who picks up the responsibility legally as well. A responsible adult who fails without reasonable excuse to comply with all of these regulations on behalf of a child commits an offence. And what's the severity of that offence? Well, it's punishable on summary conviction by a fine not exceeding level 3 on the standard scale, so a fine of up to £1,000. Finally, on these regulations, they will formally cease to have effect in 2 years. In reality, it'll be sooner. So that's where we are today. Anything happens today on Wednesday, 25 March, that is the power that the officers have at their disposal. They've had that for a while. Where are we going to be tomorrow, or maybe Friday, or almost certainly by Monday? Well, that's the coronavirus bill that will become the Act. There are a number of amendments to the bill that are still being tabled, and some of which propose, frankly, fairly significant changes to what the House of Commons originally sent up to the House of Lords. It is now at the committee stage in the House of Lords, not entirely clear what time today that's going to happen, but it's there today. So we're not really going to know the final content of the finished article until perhaps tomorrow or Friday. The current draft, this is the version that was sent to the Lords for their consideration, contains 102 sections and 29 schedules. In all of that, the most important part for police practitioners is Schedule 21, paragraph 24 of which will revoke the Health Protection Coronavirus Regulations 2020. Everything we've covered thus far is revoked by paragraph 24 of Schedule 21. However, it's not been entirely wasted time in the last 20 minutes or so, because as we'll see, much of the approach of what was clearly very rapidly drafted in understandable circumstances in those regulations has in fact survived, at least in principle, in Schedule 21. So a brief overview of the bill. There are large parts of the bill simply insert necessary amendments to other pieces of legislation. And it covers a very wide range of issues, including details regarding the emergency or temporary registration of health professionals and social workers, how to deal with emergency volunteers, health service indemnification principles, how to register a death or a stillbirth, powers relating to food supply, the power to require information and the restrictions on the disclosure information. For those of us who do coroner's inquests, there's a little part there about the suspension of any requirement to hold a jury inquest for deaths arising from COVID-19. Specifically for that purpose, COVID-19 is not a notifiable disease for the purposes of Section 7.2c of the Coroners and Justice Act 2009. There's inevitably details about sick pay, what that means and how that's going to work. And finally, although we've heard a lot of this from other courts in any event, there's detail about the use of video and audio technology in courts and tribunals, bail applications and the like. What about specifically for the police? Well, the key provisions again are to be found in Schedule 21. As I've said, this is broadly similar to the regime that we've already looked at under the Health Protection Coronavirus Regs of 2020. There's a slight change in terminology and approach. The bill affects the potentially infectious persons. That is defined as somebody who is or may be infected or contaminated and has a risk of infecting or contaminating others, or has been in an infected area within 14 days prior. Remember that sort of phrasing? That's condition A and condition B of the 2020 regs. slightly redrafted, repackaged, and brought forward into the bill. The Secretary of State's declaration, remember, that was 3rd of March 2020. That remains valid, notwithstanding we're transitioning from regs into an act. Slightly rephrased, there's a serious and imminent threat to public health in England and that these measures will be effective. Now, this again can be revoked at any time. Same point, if this declaration is revoked, all powers that hang off it are equally dissolved. But there's an important qualification which might be pessimistic. The declaration can be made on more than one occasion. If circumstances change, the current good weather, for whatever reason, there's a massive cure nationally and everyone seems to recover, the declaration will then be revoked. However, if there are then, for any reasons, a renewal of cases or reviving of the problem, the crisis, then there can be another declaration made. Under Schedule 21, a public health officer or a constable can direct a member of the public to go to a place for assessment or can remove them to such a place if there are reasonable grounds to suspect they are potentially infectious. They can only do so if they consider it necessary and proportionate. Again, we remember those words, and that it is A, in the interests of the individual, B, is for the protection of other people, or C, for the maintenance of public health. Again, all of those factors we've heard before under the 2020 regs. There is a significantly greater degree of detail in the Act to come than there was under the regulations regarding the mechanism of screening. Frankly, that really is a matter for public health officers. It's not something in which constables are actively involved. However, where a member of the public is at a place where the screening is taking place, and the constable has reasonable grounds to suspect he's potentially infectious, then the constable has a power to keep the member of the public there for a period not exceeding 24 hours. In other words, they can babysit, but with this power. So if a member of the public is at the hospital and decides they're bored, they want to go home, the police officer has a power to keep him there for a period not exceeding 24 hours. And this is a slight change from what we saw on the 2020 regs. If it can't be done in 24 hours, you'll remember under 2020, the officer who made the original decision can themselves apparently authorize a further 24 hours. That's changed. What we see in the Act to be is if it's not possible within the first 24 hours, a relevant officer defined as being of at least the rank of superintendent, that officer consents to an extension for a further 24 hours. So there's an elevation, if you like, a protection to the detainee or to the member of the public that if they can't get seen in 24 hours, only a superintendent or above can authorize a further 24 hours. We see the power to direct a member of the public to go to a hospital or a suitable place, or indeed a power for the constable to remove that individual for the purpose of screening. Those are retained under the bill, but again, only if the officer considers it necessary and proportionate and in the interest of P, for the protection of other people or for the maintenance of public health. So what happens once the assessment takes place? The member of the public is assessed by health officials, and after that assessment, the public health officer can impose restrictions, again, that are in the interest of P or to protect other people, to maintain public health. These restrictions, again imposed by the public health officer, can include the provision of information, the provision of further screening. If, for example, symptoms are in their early stages and it's not entirely clear whether they're going to develop or not, can impose a requirement for that individual to remain at a specified place. Now, if that condition is triggered, or if that requirement is imposed, that can be for a period of up to 14 days. And that period can be extended for a further 14 days. There's also a power to compel the person to remain at a specified place in isolation. So not just go home to stay with your family, but go home and stay in your room. Again, that can be for up to 14 days and again can be extended for a further 14 days. There can be restrictions placed on travel, movement, activities, contact with others, all manner of things. Again, we hear echoes in this from what was the rapidly drafted 2020 regulations. And again, as we've seen in the 2020 regulations, quite rightly, these measures must have regard to the person's well-being and to their personal circumstances. And as we saw in 2020, the person who is the subject of any of these requirements or restrictions can appeal to a magistrate's court, and the magistrate's court can either confirm, modify, or quash the requirements. Again, presumably all of these appeals, if there are going to be any, are going to be dealt with remotely, and that'll be a matter for the court service to administer. If the member of the public is required to remain at a specified place, be for up to 14 days, or to remain at a specified place in isolation, there's a power for that requirement to be enforced by a constable. Again, not entirely clear how that's going to work, but that might be knocking on doors, checking, the kind of thing that we hear about in other parts of the world today. What is perhaps surprising is that in the exercise of any of these powers, a constable may use reasonable force and may enter any place. Again, as with the 2020 regulations, these circumstances create various offences: failure to comply with a direction, or failure to comply with a reasonable instruction, failure to comply with any requirement or restriction, absconding or attempting to abscond, knowingly providing false information, obstructing a person who is exercising or attempting to exercise their power. And just as with the 2020 regulations, you are liable on summary conviction to a fine not exceeding level 3. The final part of Schedule 21, as relates to us, is that formally the Health Protection Coronavirus Regulations 2020 will be revoked. So much for Schedule 21. There are other aspects of this lengthy bill that directly impact on some of our work. In the main body of the Act itself, currently, Section 24 deals with fingerprints and DNA. It says there that the Secretary of State may make regulations extending for up to 6 months. This can be done more than once for a total of up to 12 months, extending the period for which fingerprints and DNA profiles may be retained. Now, this power can only be exercised for 3 months, i.e. up until the 10th of May of this year, and it can only be exercised if the Secretary of State considers two conditions. One, that coronavirus is having or is likely to have an adverse effect on the capacity of persons responsible for making national security determinations to consider whether to make or renew national security determinations, and it's in the interest of national security to retain fingerprints or DNA profiles. Another aspect of the bill that catches our eye is that any PCC elections that were due to be held in 2020, well, they're now going to be held in 2021. We've heard of that adjournment elsewhere in the news yesterday. I hope personally that they take a leaf out of Tokyo's book and they still call them the 2020 PCC elections. Of course, we all know they're bound to be at least as popular as the Olympic Games. Finally then, on the bill, Schedule 24, paragraph 11, increases the availability of live link for the purposes of bail. Now this, as we all know, is very much in keeping with the current raft of guidance from various other quarters, notably, for example, the Lord Chief Justice's recent guidance regarding civil and family courts. Well, so much then for a whistle-stop tour through the important parts of the coronavirus bill we anticipate is going to become the Coronavirus Act with very little significant amendment. But whilst we're on the subject, there's also the Health Protection Coronavirus Business Closure England Regulations 2020. There's a title that trips off the tongue. And these are the regulations that compel the closure of non-essential businesses: restaurants, cafes, bars, pubs, cinemas, casinos, massage parlors, gyms, etc., and things of that nature. This power that's reviewable every 28 days. The Secretary of State has designated constables as having the authority to enforce those powers. You might have seen a piece in the media recently about some pubs, I think in Lancashire, that were allegedly having lock-ins and simply ignoring these recent provisions. Well, aside from the usual powers available under the Licensing Act, of course, Lancashire officers, if it was in that county force area, might now use these regulations to bring about the closure of such pubs and to enforce that rule. Other measures announced even last night, the £30 on-the-spot fine and perhaps even of unlimited financial consequence. We can expect more announcements to follow if the legal basis for the same is at the moment a bit thin. So what we see then in the coronavirus bill/act and the 2020 regulations and various other attendant measures is a broad variety of tools now being made available to the police. We live, of course, in policing by consent, and most people will simply get it. They'll get the point, they'll get the message, but there will always be those who don't. And frankly, this is where some of these powers are likely to really kick in. You may have seen yesterday afternoon a group of 20 or so COVIDiots. Personally, I think that's a fantastic description. These COVIDiots in Coventry took the hugely responsible and community-minded decision to hold a barbecue. And they were surprised when West Midlands police officers told them to disperse. It appears they only did so when the officers, frankly, had the brilliant idea of tipping over the barbecue. And this morning, you might also, Grant Shapps, Secretary of State for Transport, tweeted that he is granting an MOT temporary exemption so that if your MOT is due from 30th of March 2020, you will automatically receive a 6-month exemption. You must still keep your car in a roadworthy condition, and garages will remain open if you need repairs. The reason I raise that is because officers will need to be aware of this. If they stop a driver and they issue an HORT1 or a producer requiring a driver to produce documents within 7 days, they now have something of a get out of jail free card as of the end of this month. So, ladies and gentlemen, that is something of a whistle-stop tour. I'm going to check on the chat now and see whether there are any questions that we can deal with now.
Barney, thank you for going through everything in such detail. We've had quite a few questions which have been written in, and I think the plan is that, if possible, you can answer a couple of them now, and then we're going to put out a detailed publication as soon as the Act receives royal assent, and we'll deal with the others in that. In relation to emergency powers, we've been asked, what is the scope in respect of the military? Is there any power for the military to support police patrols?
The military, it's a funny one. There is already in existence, and has been for many years, something called MACA, Military Aid to the Civil Authorities. This is where the military are asked to step in times of crisis, such as flooding, etc. No doubt you would have seen them all carrying sandbags, etc. recently. They've got a punchy new title, the COVID Support Force, the CSF, which contains up to 20,000 members, 10,000 reservists, 10,000 regular. They're going to be engaging or they have been engaging since Monday in training to drive oxygen tankers. They're already, as we know, looking at converting London's Excel Centre into a field hospital. They're engaged in the delivery of food and medical supplies. And of course, at Porton Down, they're assisting the research effort. Oddly, you might remember Boris Johnson 3 weeks ago suggesting the army could backfill the police under a reasonable worst case scenario. Frankly, the detail of that has not yet been published. It may, who's to say, may have been something off the cuff, who knows. Interestingly, the Ministry of Defence Police, that formal body, has not even been mentioned. My guess is that if the military are involved, they're likely to be used in the background, frankly, to enable civilian police to step forward more into the front line and deal with the public. I think that we're a very long way from some quasi-Northern Ireland position of the soldiers patrolling the streets or indeed patrolling the tills at Sainsbury's.
Barney, as you'd expect, a lot of people are very interested in the practicalities of this and what the police will actually be doing. What can they actually do? A couple of particular questions. One relates to powers for police officers to stop vehicles. What powers will they have, and how do you think they'll be exercised? Another is powers of entry. You touched on that, but how wide-ranging are the powers of entry?
Yeah, well, I think that the powers of entry are specifically incredibly wide-ranging. Under paragraph 20 of Schedule 21, they can enter any place and they can use reasonable force to do so, frankly. The vehicle point is an interesting one. Whether they'll be able to stop vehicles and conduct stop checks to see whether the journey is essential or not. Remember that even under the current privations, an essential journey is still to go and buy food. So in reality, if a policeman stops a member of the public who's driving and asks where they're going, undoubtedly the member of the public, even if they're going to a barbecue in Coventry, are going to say, well, I'm going shopping for food and I'm allowed to. So A, it's very difficult to monitor or to disprove. Also think about the mechanics of doing so. Inevitably, by stopping a member of the public in that way, you as a police officer are going to be within the 2-meter social distancing, etc., albeit for an official purpose. Do you really want to be exposing your officer or a member of the public to that degree of interaction when, frankly, you've probably got better things to do.
Leaving aside the police and looking at individuals, I know I've seen lots of things on Instagram and other social media saying that if I dob in my neighbour when he goes out for his second jog of the day, then I can pick up £150 or whatever it might be. Even if that's not true, we've been asked this: is there anything in the Act requiring an individual to report to relevant authorities anyone that poses a public risk of infecting somebody?
No, but again, there's no real triggers to how, for example, a public health official is even made aware of this. So I would imagine as a good citizen, you might do that. Query, is that going to be done for an improper purpose just to annoy your annoying neighbour? There's no provision for it, but frankly, if you report a crime, you report a crime.
Barney, I think if people haven't finished their cups of tea, then they're going to be getting cold by now. So we will leave it there, and we can answer other questions in the pack we published.
Well, thank you very much. Ladies and gentlemen, thank you again. It's a beautiful day here, and my spaniels and I need to go for a run. So keep safe, stay at home, and see you next time. Cheers.